Okay, ladies and gentlemen, gentlemen and ladies, ladies and gents. We're going to start this off by listening to a little bit of Gladys Knight, and Gladys is going to be singing a song called Home Alone. And no, it's not a Macaulay Culkin thing. It's written by Babyface, and this song came out at the right time, right about 1996. And this is Gladys at her best. The album was called Just For You. And if you haven't had a chance to listen to Just For You, then you missing something. There are two things I want to show you all today. The first thing, the first thing, we're going to go here and we're going to go here. Need to show you this. Not this stuff right here. This right here. You see this right here? The same information is in this video that's in this video. But they blocked this one worldwide. 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 See, video blocked in all countries. All countries. Okay? Because you don't play Glenn Fry. You belong to the city. Okay? You don't play Glenn Fry, people. All right? But I can play Gladys Knight. You won't say a word. And I promise you, I have more respect and appreciation for Gladys Knight than I would for Genesis or the artists who splintered away from Genesis. Yeah, I know who Glenn Fry is, people. All right, let's go back to this. I was going to do a video uh, helping some of you who are doing the fake ID thing. Ladies and gentlemen, stay away from all these idiots. These idiots will scam you and take your money. You don't want to be in touch with none of these idiots, especially the ones who come in here. Watch this. I like this thing that YouTube does, that they put the video when you scroll down, but they don't see how annoying it is. The one who put the email addresses here. Now look, ladies and gentlemen, anybody who's going to be doing work, who's going to be trying to get your services, if they use a Gmail account, please, there is no verification on Gmail. Stay away from these idiots who use Gmail account. That's why when people contact me, you see, I understand about people saying people getting over on them. Okay, that's why when I get in contact with people, I don't use my Gmail account. I use the company account. Why? Because I need them to know that I'm coming for real, that my organization is not after getting over on people. When they put their telephone number in, you see this number right here? Okay, watch this. Just want y'all to pay attention. Google search. Do a search on that stupid phone number. Why? Because when that phone number come, see, call or email them, okay? Right here. This is not a real email address, not a real phone number. This is one of those generated phone numbers they get just from any place. That's why the number keeps coming up. Now, remember, this person is talking about fake IDs, right? All right, now pay attention. Let me see if they're going to be talking about puppies and birds and other things, because I ran into that just today getting ready to do this video. So I could show you guys how fake. Look at this. Jake Blake. Oh, that is such a unique name. Jake rhyming with fake, Blake rhyming with fake. Okay? Don't fall for people like this, ladies and gentlemen. Do not fall for these idiots. All right? Because that's all they are scammers. And there are a lot of people falling for that. Ladies and gentlemen, we told you about the people out there. Now, I found out a little bit more information about the Facebook group that is like EeoN, the science of, or whatever it's called. The young lady who put that together, I don't have a problem with her. Okay? I do have a problem with the fact that she used my name. I know who she is. She used my name, and she didn't ask if it was okay. Okay? She didn't do it out of spite, out of hatred, or to cause me problems, or to get over on people. She did it because I honestly believe she was trying to help people. I haven't spoke to her, but I don't believe she had any ill intent. So, hold on. Make sure you guys understand. That's the video they took down that I was talking about, that particular website. But there's another couple of people out there that are going around saying they're me, putting up things like phone numbers. Ladies and gentlemen, first, my phone number is on the net. I have not changed it. I'm not going to be changing it. I went through too much fighting with T-Mobile, making sure they kept my number because they did try to change it. And I said, oh no, by the way, I'll be sure singing Hotel California. Okay? Look at that. A Genesis song. You can't make this stuff up, people. I didn't plan this. On a dark desert highway, cool wind in my hair. He's a black man. He ain't got no wind in his hair. Our hair doesn't blow in no wind. It's as stiff. Anyway, ladies and gentlemen, so that all of you get it, so that all of you understand it, because you don't get it. If you want to get in touch with me, there's a gentleman who paid for a consult. He is able to get in touch with me. He gets my direct number. We communicate. He knows it's me because he can hear the voice. I'm not going to communicate with you through no text messages and no emails. People, I don't like texting. Sorry. Whew. That's what the new people, they don't realize that there's just certain things I don't do. I'm not trying to fake the funk, people. I am not trying to hide. That's why I put all of my business out there. Ladies and gentlemen, I'm not trying to scam nobody, and I'm not going to stand for nobody scamming you. I told you I will not let nobody pimp you, which is why I go through all of this. It is 7:47, and I am extremely tired, but the information I want to give you tonight, this is for you. This ain't for me. I'm not doing this for my health, okay? But I definitely want to let you know, stay away from all of these idiots. Ladies and gentlemen, these people do not, if they do a YouTube video and they're talking about, they're not going to advertise themselves like this. Okay? And if they give you that, well, either you want it or you don't, that don't work either. You better send me something. Okay, you do the ID, now send me a photo of that ID, front and back. And put today's newspaper next to it. And do it close up because I want to see the ID. And then I want to make sure that it's actually done. And I will, by all means, send you the funds. But I'm not using no Bitcoin. Ladies and gentlemen, do not use Bitcoin. Do not use Bitcoin to make any purchases. Do not use any of that stupid currency. Look, it has its benefits for the people who are trying to hide stuff, but stay away from Bitcoin. There is no guarantee. These people will take your funds and walk on with it. Don't let them do that to you. Okay? There are your warnings. There are a lot of people who are going to hate me because I just talked about Bitcoin. They're God. But Bitcoin, okay? Bitcoin's a piece of junk. It's a fly-by-night so-called currency. And what's going to happen to that currency? Well, they're going to regulate it. You know that that's coming. And then they're going to manipulate it. Just like you saw how big of a drop it had, because the government came in and manipulated that. Why? Because the next thing they do is they come in and they take it over. Why? How do they take it over? They buy stocks. Remember, Bitcoin is sold and traded on the market. The government comes in and buys up the stock, people. They come in and they become the owners and then they manipulate it from there. They do it all the time with companies. And you guys who think, well, we're running from them. We're running as fast as we can. You're not running from anything. Okay, now, enough about that. Like I said, this wasn't the reason for this video. That's what I was going to talk about. But I decided that I want to give you something that's going to be a little bit more benefit to you. I created this document for two people who are going into court. Because, see, the court says that you don't have an entity. They don't recognize that party, that you must be crazy bringing up all of that bull crap. That's that sovereign in this stuff. Okay, we're going to read this whole thing. Hey, Al, go ahead and let them know he's about to end Hotel California. I just like the bass in this. And when you play it in the right system, This song by L.B. Shore, it's all right. Hotel California, L.B. Shore. Um, I have to hear one more before I'll be sure. Okay, that's where he got his name from. The Dana Dane song, Cinderella or Cinderfella. Sorry, Cinderfella. Sorry, Dane. Cinderfella. Dana Dane. Okay. I'll have to hear one more before I'll be sure. Oh no 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 no! I said Cinderfella. No, Dana. I'm really sorry. That was Nightmares. I apologize because I went over the whole song in my head just now, and it's Nightmares because he's sitting before the psychiatrist. Oh Dana! It's Dana! Oh no! He's right here! Oh, have a seat. Okay. Okay, that's from that song. That's where Al.B. Shore's name came from. His name was never Al.B. Shore. That's his stage name. Quincy Jones. Gay mother. Sorry, not Al.B. Shore. Quincy. Sorry, can't stand Quincy. Okay, I don't know why. Oh, ain't no women gonna talk about Quincy because he's gay. Anyway, I'm sorry. I apologize. I'm gonna end up like Tupac now. I'm sorry, Quincy. Anyway, yes, that was a real big play on words, considering there's a conspiracy theory that Quincy Jones had something to do with Tupac because Quincy Jones asked Tupac to wrap his lips around something, and Tupac, basically, whew, was getting ready to tell the world about that mother. Okay, and next thing you know, Tupac ain't here no more. Uh huh. Anyway, let's talk about the court, ladies and gentlemen. We got Luther in the background, and this is me. I trust people. Luther swore up and down that he wasn't gay. No, he didn't. Everybody else kept saying Luther was gay. Luther never commented on it. Okay? Turns out there was some truth to that. But that's that old man's private life. Ain't got nothing to do with me. That's Luther. I didn't listen to Luther because of his beliefs. I listened to Luther because the man could sing. I don't care about that other stuff. Oh, you guys don't care about that other stuff either. Get on into the conversation. You've already read all the way down to is, and you read the period, and you've anticipated what it says next. All right, let's read this. Okay, let's read it. I stand here before the court this day, completely and utterly amazed to have the judicial officer say that it does not recognize the difference between a natural person, a legal person, a juristical person, and an artificial person, an instrumentality, an entity, and the different characteristics of each. The judicial officers of the court are said to be learned persons, which means that these things must, that these are things they must understand before they ever hear a matter. Ladies and gentlemen, they are learned individuals. They are supposed to know the law, okay? Just like you're expected to know the law, because ignorance of the law is no excuse. So you have no excuse for not knowing the law, so you're expected to know the law. The law makes it clear that in bankruptcy, a non-individual is defined in statute and not according to what a judicial officer may or may not infer. That's right. A non-individual is defined in statute, not in the judge's stupid mouth. For instance, the court, through this judicial officer, has not said that the debtor or the defendant, for those of you who are in criminal matters, of this matter, a non-individual is not recognized by the court as such. Okay? The court, they will never tell you, well, the court does not recognize the defendant to be a non-individual. They will never say that. I guarantee it. Okay? I need for the court to state emphatically on the record that it does not recognize the debtor or the defendant, and you say the name, with the name rendered in all capitalized letters as indicated in the court caption as a legal name, legal person, an artificial entity, as the facts show that it is. Okay. If I'm understanding the court through its, and that's supposed to be it's, not his, so I got to change that. I sent this out to everybody and thought I went over it already, but got the itis. Okay, through its judicial officer, correctly, the power of attorney placed into the record That's right. If you are in court, you should be coming in there with a notarized power of attorney to speak on behalf of that entity. A general power of attorney, not a specific power of attorney, general power of attorney to speak on behalf of that entity. Don't worry about what happens after that. Get the power of attorney over the entity first. That's why we do the affidavits, ladies and gentlemen, the POAs. You'll see in a minute. Into the record was not a special power of attorney, but a general power of attorney. And because it was a general power of attorney, it did not need to specify that it was to include bankruptcy matters or criminal matters or civil matters. As such power of attorney was placed into the record of this matter, the court, through its judicial officer, seems to infer that it does not recognize power of attorneys in bankruptcy or criminal matters or civil matters, or blah, 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 however you want to put it, unless and only unless they specifically say that it is a civil power of attorney, criminal power of attorney, bankruptcy power of attorney, what's the other one? Equity power of attorney or probate power of attorney. Is this correct? Whatever the situation is, this is an all-purpose response to these idiots. Remember, what they do is they get attorneys to go over videos like mine. And when they get these attorneys to go over videos like mine, what do they try to do? They try to outthink me. Okay, fine, go ahead and try. So I'm gonna hit them at every single point, every single angle. I don't just use one barrel. I don't just use one gun. I don't just use one weapon. I don't just use one shoe. I don't just use one angle. I want to come at them from every angle. So while they're looking in one direction, my goodness, boy, how did you get there? You caught me by surprise. I'm almost in my pants. Come on now. Okay, that's what I want them doing. On the issue of signing under penalty of perjury. First, this is when they claim people signed something under penalty of perjury. I didn't sign under penalty of perjury, but if ever I do, it is never my intent to perjure myself or anyone else, because intentions is everything. So you have to say you did not intend for whatever it is they're claiming is done that you were supposed to have done. It was never my intent to do that, because intentions is what they prove when they're supposedly in court. They have to prove what your intent was, and so you have to kill that intent on the record at the very beginning. My intentions were honest, and the documents filed were on behalf of a legally recognized entity, agency, instrumentality as cognizable in law. For even the bankruptcy code, as well as the forms for bankruptcy court, recognizes the difference between a natural person and a legal person. For it lists one set of forms for a natural person, i.e. an individual, and an artificial person, i.e. a non-individual, in its documents. My filings were for a non-individual, and everything in my filings applied to the non-individual. I believe that the confusion lies with the court's judicial officer failing to understand the purposes of its own forms. I didn't say its own because it doesn't belong to the judicial officer, so I said the purpose of its forms. Hey, we can't play this song, y'all. Although I do like this song, this ain't one of them appropriate song type things, because they talk about some things in that song, and it wasn't until recently I started really listening to the words. Ooh, man, that song right there, can't play it, so I won't do it. There's Mary J. Blige, okay, in the background. But that was Drew Hill before that. Yeah! Okay, hey, can't do that. That video, that song, when it first came out, man, that had me going. I was listening. Okay, keep going. Okay, I apologize. On the issue of abusing anyone's system, there is nothing in the documents presented to the court that were in affidavit form that are in any way an attempt to abuse anything, anyone, or any person. Those forms were specific for a specific reason, which includes the following. Ladies and gentlemen, remember I told you about intent? We did the video the other day telling you that the courts must go according to the intention of the Congress. Pay attention. That the United States Congress has indicated that we are still under a banking holiday, national emergency as a result of the March 9, 1933 Act. This is an undisputed fact. Not indisputed, undisputed, because nobody's ever disputed the fact that we are in a banking emergency. Nobody has ever said, no, we're not in no banking emergency. No court has ever said that. No court has ever ruled that. Congress has never said that. In fact, Congress said that we are still in an existing emergency. We're going to talk about that in a minute. That the United States Congress has acknowledged as a result of the March 9, 1933 Act that all normal banking activities have been suspended. Has been. I didn't put have, has been, because it's continual. Okay? Has been suspended. Okay. You a has been. I ain't no has been, mother. Okay. Anyway, that the courts must go according to the intentions of the legislature. And in this instance, the legislature gave us their intent when it stated the following when creating the March 9, 1933 Act, that the ownership of all property is in the state by virtue of the government. Senate document number 43, 73rd Congress, first session. Under the new law, government obligations will represent a mortgage on all the homes and all of the people of the nation. Congressional Record, March 9, 1933, H.R. 1491, page 83. As it is a fact that all property in the United States as a result of the March 9, 1933 Act is under the ownership of the United States and or its designee, it is impossible for me to be held liable for government obligations, as the court seems to presume and first suggest allude to. And on the issue of my right to file bankruptcy during the national emergency, it is because of the national emergency that I have to, that I have this exclusive right. For if we were not in a national emergency, which Congress has said is serious enough to halt all normal banking activity, there would be no need for bankruptcy courts in the United States. There would be no need for quasi-criminal courts in the United States. There'd be no need for quasi-civil courts in the United States. Remember, quasi. Okay, quasi. Look up the word quasi and you'll see why you're saying quasi. Oh, that's a good name. I'm going to call myself Quasi. I'm going to start a new YouTube channel and call myself Quasi. So everybody call me Quasi because I just came up with the name by listening to that idiot EeoN. Anyway, Quasi. Okay, anyway, let's go on. The court asked me to show cause. Yeah, I know somebody's going to come up with a name now. Hold on. I just want Quasi. Okay. Let's just do Quasi. Dream away. Y'all remember Color Me Bad? I want a second. No, you ain't second nothing. Oh, hey, look at that. Too many people already got Quasi, so y'all can't choose it. Y'all can't use it. They already got Quasi. This one's Quasi's got 106. My goal is to make your day a little bit brighter with humor in my videos. Quasi, look at him. Okay, Quasi, 10 videos. So there are two Quasis. This one's all capitalized. How do they do that? How do YouTube have two sites with the same name, but just capitalization and lowercase caps? I know some of y'all gonna want to call yourselves Quasi 2, Quasi 1, Quasi 3. Ladies and gentlemen, don't worry about it. You ain't got to do that. Okay, you're gonna then create another way to say Quasi. Don't worry about it. All right, let's do this so that you get this understanding. The court asked me to show cause. And look, they asked you to show cause without them even giving you an order to show cause. The moment they ask you to appear in court, the moment they give you an order to show up in court, they're asking you to show cause for why you should not be there. The court asked me to show cause, and I present before and place on the record of this court by reference the March 9, 1933 Act and the unconstitutionality of that act as specified in Congress's own words. Since 1933, the United States has been in a state of declared national emergency. That's right, declared national emergency since 1933. Okay? All right. These proclamations gave forth the 470 provisions of federal law. These hundreds of statutes delegated to the president extraordinary powers exercised by Congress. Delegated to the president extraordinary powers exercised by Congress, which affect the lives of American citizens in a host of all-encompassing manners. This vast range of powers taken together confer enough authority on to rule this country without reference to normal constitutional process. Now hold on, I'm gonna break it down so you understand. That was 1973, July 4th, 24th that they said that. According to the United States Congress, the United States Congress not only conferred its authority to the executive branch, but they also delegated to the president extraordinary powers in violation of the Separation of Powers Clause. These two acts, in and of themselves, make this act unconstitutional. And I challenge that act as unconstitutional, and it is directly and indirectly related to this matter, as is my right. You got to challenge the statute as unconstitutional. And you have to do it on the record, people. That is the rule, that is the law, that is the fundamental principle. So I've just given you the reason to challenge it, because Congress itself said that it gave the president of the United States, the executive branch, look, these hundreds of statutes delegate to the president extraordinary powers exercised by Congress, what's called delegation of authority. Congress cannot delegate authority to the executive branch. The executive branch cannot delegate authority to the congressional branch. They've already made this decision. It's called delegation of authority clause. It's in the Constitution. That's where you get the separation of powers clause. But not only did they delegate power, but they conferred power. Pay attention, conferred enough authority. They cannot confer their authority on any other branch of government. So those two acts, their delegation and their conferring of power, were violations of the Constitution, which makes the act unconstitutional. And it's not, well, any provision of this act deemed to be unconstitutional does not get rid of, eliminate, or blah, 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 blah. No, don't work that way. Okay? The bankruptcy rules, the Bankruptcy Act, you can go the Rules of Criminal Procedure and the U.S. Code or the state's penal code, and the bankruptcy procedures all stem from the March 9, 1933 Act, an act deemed by Congress to be unconstitutional. I didn't say it was unconstitutional. Give me that DeBarge. That's El DeBarge, y'all, and his brothers and sisters. He's a grown man. He's come a long way. El DeBarge, y'all. Congress said it was unconstitutional. This vast range of powers together conferred, or taken together, conferred enough authority to rule this country without reference to constitutional process. See, it says normal. Well, we weren't in abnormal. You're a little bit too loud for me, L. Well, you're going to have to take me turning you down, El DeBarge and DeBarge. They used to be switch. Anyway, so if this court will insist on operating in a fashion that does not permit me to speak on behalf of the legal entity created as a result of the congressional act known as the March 9, 1933 Emergency Banking Relief Act, I must hereby elect to challenge the court's jurisdiction in this matter. I would also remind the court that a bankruptcy court, criminal court, civil court, whatever type of court it is, that a bankruptcy appeals, see, it's not supposed to be appeals, it's supposed to be appeal. So I have to change that. I'll send it to the two women so that they will have it, because this is what they're going to be going over. That a bankruptcy appeal has been had in the previous matters it alluded to, which effectively, as it is a bankruptcy matter, stays the order of the court until the matter has been properly heard by the bankruptcy appealing court venue. At least that is the normal course of business. And that was my intent when I was operating as attorney in fact for the entity that is listed in these documents as the debtor. I was very specific in my documents by referring to myself as an individual and the entity as the non-individual. Since we share the similar name type, similar name font, similar name style, similar name pronunciation, with so many similarities, there had to be distinction. And I made it a point to distinguish between the two entities, natural and legal. Now, let's go on. It is to be noted that the court, through its agents, did the exact same thing by placing in the caption, or by placing the captioned name in all capital letters and the individual name in upper and lowercase letters. This was done purposely and with knowing intent, and I must object to the inference as expressed otherwise. We say that what they did was with knowing intent. that they did it deliberately. Okay, so I say to this body that the issue here is whether or not I had the right to speak on behalf of the entity created as a result of an act of Congress, when explicitly and especially there is no statute or other governing law prohibiting such. That's right, there is no law prohibiting you speaking on behalf of that entity, especially when you have a power of attorney. That's why you get the power of attorney notarized, giving you authority to speak on behalf of that entity. It's called a durable power of attorney. We have one up on our site. Not the one we use for our clients, but we do put up a general one up on the site for all of you to have. I tried to explain this to the court judicial officer, and it ignored me. See, we called the officer an it. Okay? So I notify this court here, this day, that I am not here to argue, that each of its questions have been thoroughly answered in this presentment. And if it has more questions, it will have to place them in writing because I am not willing to be subjected to undue surprise. That's right, they cannot surprise you with a question. And you, with a document like this, you simply let them know I've already responded to that question in my presentment there. And if you didn't understand it, that my saying it again is not going to help clarify your understanding. Once those questions are placed in writing, I will provide a written response to the court so that it will be documented as evidence for the record. We didn't say on the record, I said for the record, because I don't want any misconstruing of my words or trying to make it seem as if I don't know what I'm talking about. I will provide documentation and proof of every single issue to be discussed. I thank the court for its time and its consideration, and I ask that it please either allow my bankruptcy to proceed or allow me to proceed to speak on behalf of this entity and or provide me with the proper mechanism and procedure for filing a claim against my constitutional act contract entity, all caps name, a non-individual as defined by statute. See, we're saying constitutional act entity or constitutional contract, because the Constitution or congressional act, congressional contract, that's a contract. March 9, 1933 Act is a contract. Been telling you guys that from the very beginning. That's the agreement. That's the bankruptcy. You all been hearing about the bankruptcy of the United States, March 9, 1933. That's the act. That's what allowed all of this. Anyway, and I present this before this body this day and ask that it reconsider its previous orders and motions in light of the facts it has not taken into consideration that I brought before it this day. There you go. Two people who have the court wanting to be hard on them, wanting to be angry at them, pretending to be angry. So now we give them something to put on the record. See, we can't stop them from the course that they're headed on without bringing up certain things, putting them in a bind. And I promise you, this puts them in a bind. This protects them, the two women, but it puts the courts in a bind, but it protects the two women who are going to be going before the court on a show of cause hearing. But before you even get the show of cause hearing, this is the information that people should be putting on the record. Now, with that aside, okay, with that aside, we're going to close this because I got to send this to those two because I made the two corrections in the wording. Somebody sent me this tonight. I told them I'd share it with you guys. I'm sorry I can't make it much bigger, but this individual does this and he's speaking about how the system operates in the OID and he talks about the IRS and everything. And I'm kind of liking this because these individuals, pay attention, have been doing the IRS thing for a while and have been standing on their own, okay? And no, I can't understand it. Oh, I can understand it. It says no additional OID need to be filed since the nominee has already filed OIDs on the estate's behalf. Once the estate receives recipient copy of OID, funds can be claimed on a tax return. For 1099 OID, see this code here. For 1099A, see that code. Okay, ladies and gentlemen, as you know, I don't talk to you guys about OIDs or taxes, okay? But what I will tell you is there have been people out there who have been very successful when they do it right and when they try not to be greedy. The IRS is not going to bother you guys for getting what's due you for your estate, but they will come after you if you're sitting up there trying to get hundreds of billions or quadrillions of dollars. Why? Because now you are causing damage to the system. They are not going to let you damage the system, people. You guys need to understand that. But as long as you operate in honor and you do things honestly and you don't get greedy, man, they ain't gonna be, get them out of my face. They don't want to be bothered with you. Okay. Then it says how to calculate OID for a loan with the maturity date. They even tell you how to do all of that. Okay. So a person sent this to me. Can you send that a copy of that? No, I'm not sending you a copy. You better go to this video and put it on pause. Put it on pause. Now I want to tell you, this person sent me this document. Okay, and this is their document. Uh, I haven't been given permission to show you the whole thing, so I can't show you the whole thing. But what I can tell you is they put the Emergency Banking Act of 1973 Congress. They understood it. They now understood and understand that it is not no so-called HJR 192. You got to understand, HJR 192 didn't do nothing. But notice what they put in here, Section 401, sixth paragraph of Section 18 of the Federal Reserve Act of 1913, which is still in effect. Upon deposit with the Treasurer of the United States of any direct obligation in the United States on any notes, draft, bills of exchange, bankers' acceptance acquired under the provision of this act, the Federal Reserve Bank making such deposit, see, says upon deposit, that says the Federal Reserve Bank making such deposit in a manner prescribed by the Treasury, Secretary of the Treasury, shall be entitled to receive from the comptroller of the currency circulating notes in blank. In blank, they get to set their own value, duly registered and countersigned when such circulating notes are issued against the security of obligation of the United States. The amount of such circulating notes shall be equal to the face value of the direct obligation of the United States, so deposited as security. And when issued against the security notes, draft, bills of exchange, bankers' acceptance, acquired under the provisions of this act, the amount thereof shall be equal to not more than 90% of the estimated value of such notes. That's why you pay 90% of the loan. Draft, bills of exchange, bankers' acceptance, so deposited as securities. Your mortgages, people. Okay? Do you understand, ladies and gentlemen? Now, they put, this was the amendment, Section 401. That's part of the Emergency Banking Relief Act, ladies and gentlemen, of 1933, the March 9, 1933 Act, which amended parts of the Federal Reserve Act. This is what's going on, and I appreciate these guys for taking the time to go over that act to see how it is impacting us this day. That's why I'm showing you guys this. All right, ladies and gentlemen, that's all I can do for you this evening. Look at that. The cat feels like I feel. It's time to go to sleep. Oh, Whiskers, come on, Whiskers, let's go to sleep. Why do you call cats Whiskers? Because they got whiskers. But a lion has whiskers. Yeah, I call a lion Whiskers too, but he ended up slapping me. Anyway, ladies and gentlemen, I can't understand it. Y'all hear my man talking about that? Baby, baby, baby. Okay, don't y'all miss my boy? Don't y'all miss my boy? Do it on the good foot. Do it on the good foot. Lordy, lordy. Don't y'all dare put down the man with a better hand. All right, ladies and gentlemen, gentlemen and ladies and gents, thank you for allowing me to bring this information to you. I hope that some of the information proves to be of some benefit to some of you. Some of you, I had somebody say this evening, and this will be the last thing that I speak on before I discontinue this call, but I had somebody say to me this evening that they listen to the videos and they see that in the videos, I'm not giving all the information, that I'm kind of leaving things out. Ladies and gentlemen, I'm not leaving things out per se. I'm giving the information, but the problem is I can't anticipate your questions because I don't think like you. As a matter of fact, I'm explaining most of the things in my videos, not to the lay person. I'm explaining it to the people who already have knowledge. You guys just saw what I just did. I showed you the video of not video, I showed you the document of the individuals who took what I talked about and they went and expounded on it. Okay? Okay, ladies and gentlemen, that's what I'm talking about. Those are the people I'm talking to because those people are going to do the research that you can't do. Why? Because they've already done it. See, you are starting from the beginning. You cannot start researching from the middle of a book if you want to find out everything that's in the book. Okay? So you have to start from the beginning. These guys don't have to start from the beginning, and nor can anybody, including myself, explain things to you from the beginning. It will take too long. That's why, thus far, it has taken us doing these videos going on 6 years. Okay? 6 years, 5 million views thus far. And that's just for now. Again, we don't advertise. No advertisement. No advertisement. Okay? But a lot of views, a lot of people, but a lot of information. So, those of you who are really gaining something from this, hey, I say hang on in there. Hang on in there, baby. Okay? Just hang on in there. Everything will work out. There are some things happening this year. I've already told y'all, you talk about this flu season is supposed to be the worst flu season in so long and all that stuff. Y'all knew about that. I told y'all that they were going to have school shootings at the beginning of the year, and that's what Congress was going to focus on at the beginning of the year. And we just had a school shooting, 17 people injured, 2 people dead. At least that's what I heard the latest. Okay, that's what I heard because I don't watch the news. But I promise you, beginning of the year, gun control is going to be their main focus. They threw all of you off by doing the government shutdown. They shut down the government, y'all. They shut down the government and they were going to make things real hard on people. They could have shut it down December 23rd. Whoo, doggy, they didn't want riots in the streets. That's why they passed that temporary bill. Okay, and now you got 3 more weeks, temporary again. If they were really concerned about the budget, then why did they go on vacation when they extended the so-called temporary spending gap for 3 weeks, 5 weeks, whatever it was, December 23rd? Why did they go on vacation? Why did Congress take a recess, winter recess? Why didn't they stay in the office and fight for that? Didn't they want to fight for their little so-called tax plan that they just had to get out before the end of the year? Before getting the tax plan, why couldn't they work on the budget before getting a tax plan? Don't you guys see the manipulation? So now that you know, you can better prepare. Ladies and gentlemen, quit fighting the system. The system is not designed for you to fight it. You fight the system will fight back. No, no, no. You are to use the system to your advantage, and it can be utilized to your advantage. You just have to figure out and understand how. Again, in the next couple of days before Sunday, I'll be putting out 3 videos. We'll be sending 2 of them to our members, letting them know what the next stage is. And to you guys, we'll be giving you a better understanding of what SATCOM is designed for and how SATCOM is doing what it does. Because we do have a lot of people out there, guys, there are a lot of people trying to duplicate what we're doing. They're buying into the program because they want to add to what we're doing to what they're doing, but they don't understand there are some things we're doing on the back end that we don't tell our clients. Okay, we don't give you copies of that, so you're going to be missing some steps because, sorry people, I was born last night, not yesterday, so you can't get over on me. We're not going to let that happen. I told you, this is not that type of party. Not for you to come and just take and manipulate and think that you're going to, ooh, can't do it. Can't do it, can't do it, can't do it. Oh, look at that, flat earth. Just so flat. Look at that. See how flat it is? Anyway, gotta go. Y'all take care. Have a good day. Have a good night. Have a good bye.